All right, I think we could probably start jumping into this. Thank you for joining us today. This is our webinar on compliance and best practices for Michigan cannabis operators. My name is Travis Copenhaver. I'm a partner at Vicente. I am the managing partner for our Michigan office. I'm joined today by our Director of Regulatory Compliance, Genevieve Meehan. Genevieve, you want to say hi? And oh, you're still muted, Genevieve. And
Hi there, I'm the Director of Regulatory Compliance. I support clients in many states while maintaining efficiencies in their operations and implementing comprehensive compliance programs.
Awesome. We're also joined by attorney Krissy Atterholt. Hi, Krissy. How are you today?
Good. Hi, I'm an associate attorney for the Michigan office, and I previously clerked for Vicente's Los Angeles office as well.
Awesome. Well, we'll jump right into it here. Just to give you a quick overview, we're going to go over some recent trends in the cannabis regulatory agencies' enforcement policies. Then we're going to talk about how you can create a culture of compliance in your business, what to expect, and some tips and tricks on how to deal with common compliance issues in Michigan. We're excited to talk to you today. So to start, when we're talking about compliance, what we're typically referring to is your obligations as a cannabis license holder to comply with the various laws, administrative rules, local municipal ordinances, and other obligations required by law for you to operate a legal facility. The primary documents we're going to be referring to and where most of these requirements come from are the two statutes, the Marijuana Facilities Licensing Act and the Michigan Regulation and Taxation of Marijuana Act. Marijuana Tracking Act, and then there's also various resources on the Cannabis Regulatory Agency's website. Those would be CRA bulletins, Metrc bulletins, and then to a lesser degree, your actual police power and zoning ordinances for the municipality your facility is going to be operating at. All of these different sources create a different set of obligations, different license types need to comply with in your day-to-day operations. We're going to talk to you a little bit about what those basically tell you to do and how you can operate at a higher level and help your business stay afloat. To start, the Cannabis Regulatory Agency recently had a new director, Director Brian Hanna, and in his new administration coming in, they have made it a priority to ramp up the CRA's enforcement and compliance and inspection policies. So to start, we're going to let Krissy kind of walk through what that's looked like over the last few months and some things you can expect. Take it away, Krissy.
Thanks. So every month, the CRA provides a disciplinary action report that kind of details the formal administrative complaints and disciplinary actions taken against adult use and medical cannabis entities in Michigan. So I reviewed the reports dating back from March 2022 to this March. As of last month, there's been roughly 272 disciplinary actions taken against Michigan cannabis businesses. And some of those actions listed multiple bases for action. So that could be non-compliant sales and Metrc non-compliance or a combination of other categories. So of those 272 disciplinary actions, there were 13 different bases for their actions. And you'll see those categories on the chart on the screen. CRA is not limited by these categories, but these are the ones that were either discussed on their websites or mentioned throughout the reports that I read. These include things like failure to report material changes, issues with surveillance and security, general operational issues, infractions, and non-compliant sales, and many others that you see. So the top three reasons the CRA took action over the last year include annual financial statement non-compliance that comes in around 36%, sampling and testing infractions at 14.9%, Metrc non-compliances at 12%. We typically see annual financial statement non-compliance stemming from late submissions, sampling and testing infractions coming from the actual reporting of the test results. And Metrc non-compliance can look like many things, such as incorrect inventory, products not being properly identified in the system, products being found without tags, and other Metrc compliance issues. So kind of getting an idea of what the CRA has been more recently focused on, I'll kind of break down what's been happening this past March. There were roughly 30 disciplinary actions in the month, and there were 9 categories listed as far as infractions go. So the top 3 leading reasons for March was Metrc non-compliance at 33%, non-compliant transfers between marijuana businesses at just 14%, meaning there was either perhaps like a backwards transfer in medical license supply chains, the products weren't listed appropriately on the manifest, or maybe they were using an unregistered vehicle to complete the transfer, or other similar infractions. There's a tie for the top third leading basis of action, and these represent just 4% of those enforcements, including packaging and advertising, AFS noncompliance, and noncompliance sales. Next slide, please. So there are multiple penalties the CRA may impose, including not imposing a penalty at all. However, the CRA is also free to impose multiple penalties depending on those circumstances. So from March 2022 to this March, we can see that the CRA withdrew the formal complaint 57.6% of the time. They did impose a fine 35.3%. And then the rest of the penalties occurred just under 2% of the time. And those were for things such as summary suspension, or perhaps requiring the entity to update their SOPs. But we do see a change in penalties for just last March. The top penalties for March were actually 67% of the time the CRA imposed a fine, compared to the yearly average of 35%, withdrawing a complaint 33% of the time compared to the yearly average of 57.6%. So this kind of indicates a possible trend of increase in fines rather than withdrawing the complaint that we've seen. Next slide, please. So I think it's just kind of important to note that, yeah, there is an increased enforcement. We can see that the average disciplinary actions a month have gone up significantly, kind of like Travis was saying with the appointment of Brian Hanna. And since, or prior to September of 22, which is before he was appointed, we saw an average of just 5 disciplinary actions a month. And now we're seeing in 2023, 27 actions per month. And we have some outliers. July, there were no enforcements. And then October of 2022, we saw about 80. I guess I just want to leave you with like a few takeaways. The CRA is increasing enforcement. We're also seeing a possible increase in CRA imposing fines rather than withdrawing, as indicated by the 67% of entities being fined just last month. And of course, there are many bases of action the CRA is considered, but the current top 3 are AFS noncompliance, sampling and testing, and Metrc noncompliance. But with this increased enforcement, those categories might really change. So we'll have to keep an eye on that. Genevieve and Travis will kind of talk to you now about how to prevent your company from getting caught up with CRA's increased enforcement and fines.
Thanks so much for that valuable information, Krissy. I think having a pulse on the current enforcement trends really helps us kind of inform our culture of compliance. A comprehensive and coordinated compliance program lends to a proactive approach to tackling complicated compliance issues. An effective compliance program should consist of written policies and procedures, designated responsible compliance personnel, conducting effective training and education, developing clear and efficient lines of communication, setting a cadence for internal monitoring and auditing, enforcing standards internally and not just waiting for regulatory enforcement or taking a reactive approach to regulatory enforcement instead of a proactive one, and responding promptly to areas of non-compliance to implement a solid corrective and preventive action plan. The slide that was just put up will give you some tips on how to foster your own culture of compliance in your business. They include training and continuing to retrain your employees with an eye towards compliance, reiterating compliance, as well as your company's core values and quality standards in everything that you do. I think it's important that compliance folks really understand operational efficiencies, but not overstep what they're doing in day-to-day operations. Most operators know that there's a kind of this friction between compliance team and your operational goals that does create a sweet spot where a lot of your best work is actually getting done. And I really like to encourage teams to leverage that friction into something great. Create clear compliance processes that are easy to understand. If your processes aren't being followed, I think it's important to ask your team why. Often there are resources or training or materials that can be empowering to your team to take more proactive next steps in this culture of compliance. And finally, establish a cadence of accountability and responsibility within your compliance team and day-to-day operations so that there's a clear authority on next steps. Next slide, please. That said, something that we're often asked about in Michigan is preparing for regulatory inspections. The best way to prepare for your regulatory inspections is to train your team to be ready for them. Appoint team members who are in charge of walking through day-to-day operations with a regulator if they should arrive on site unannounced. Conduct mock interviews or empower your team with resources so that they can remain focused and calm during an inspection. I've often experienced quick questions relating to security or surveillance when you're moving through your IT systems on the spot. It does feel like a lot of pressure. So training for that can really support how smoothly your inspection runs. Also note that cooperation is key. Next slide, please. All employees must cooperate with CRA personnel or any other official that enters the premises. It's important not to deny entry, falsify any information or documentation when prompted for it, and not be defensive about jumping to conclusions with any inquiries that are being asked. And definitely don't delay your response times if you're asked for specific documentation. You're often given a little bit of a buffer between their time on site and when certain documentation needs to be sent, if it's being sent via follow-up email. But I think it's important to respond pretty quickly. Next slide. The best way to avoid costly and time-intensive enforcement actions is to set a cadence for on-site audits every month with your team. This slide provides an overview of the kinds of things that you should be spot checking for. I encourage you to empower your team members to collaborate, cross-audit various departments or areas where they're not regularly working, and really lean into their own comfortability with the materials that they are auditing. This does not only help them be ready for on-site inspections with regulators, but it also prevents issues from popping up in day-to-day routines. Issues that are caught and remediated quickly are much easier to mitigate than issues that go unnoticed for several months. Next slide, please. With that in mind, it is also important on a quarterly basis, is what I usually recommend, that you connect with a different third-party auditor. A fresh pair of eyes walking through your facility can help you with calling out compliance errors that may be right in front of you and going unnoticed. Our team has detailed checklists and notes, and because of our insight into high violation areas, we're able to help you restructure and strengthen your compliance program's weak points ahead of costly fines or lengthy proceedings. Let's move into some of the documentation overview, please.
Awesome. Well, just to jump in here real quick, creating a culture of compliance is really important because you know that at least twice a year, often more, the Cannabis Regulatory Agency is going to be doing a scheduled inspection of your facility. They actually make their inspection checklist available to you on the CRA's website. I'd encourage anyone who has responsibilities in these areas to review those. And they really make it easy. They walk through and tell you exactly what their highest enforcement priorities are. However, as I'm sure you all know, when they are in your facility and they're walking through, they're looking for a lot more than what's on those lists. As we're kind of going through here, we're going to talk to you a little bit about kind of what the trends in Michigan are, why we're making recommendations of this type, and kind of go over a little bit of what you can expect if you haven't really had any of these kind of interactions with CRA or local law enforcement. So I know we skipped over a slide. It's when to self-report in Michigan, and we're going to kind of use that as the through line here as we kind of walk through the last slides in our presentation. In general, it is important to know that in most cases, if there's an incident on your facility, the rule of thumb is really to, when you have notice of it, make best effort to make reporting to the regulators within 24 hours of your knowledge of that incident. There are certain situations where you have a little bit more leeway in some cases, but there are administrative rule requirements in some instances where you have by rule 24 hours to make reporting. So those are incidences that would include criminal conduct at the facility itself, any incidents of loss or theft at the facility. You're required by rule to make sure that you notify the CRA within 24 hours. You also have some additional reporting requirements written right out in the rules and statutes that we'll be going over. We'll kind of talk about them and give you some examples of some of the most common areas as we go forward here. But go ahead, Genevieve. Sorry to jump in there.
No worries, appreciate the insight. On the next slide pertaining to documentation, I just wanted to note that if you're not documenting it, it might not be happening. If you don't have written policies, procedures, standards of conduct, or clear checklists or logs that account for the cadence of responsibility in your day-to-day operations, your team might be missing key action items that keep your operations both efficient and compliant. Next slide, please. So Travis and I are going to dive in onto some of the gold standard for SOPs, basically having a complete overview of the laws and regulations, having a game plan for incorporating compliance into your operations, such as a work instruction or clear checklist for your team, creating and maintaining the documents in accordance with a document management system or a tech solution so that you can clearly track updates and changes to the documentation. And most importantly, making sure that the SOP documents are actually implemented on site and consistently reviewed and revised.
So just so everyone's aware, if you were not, Administrative Rule 420-206A requires all cannabis facilities to have up-to-date written standard operating procedures at the facility at all times. The CRA also can request that you provide them a copy of those SOPs within 24 hours. I won't read you the rest of the rule, but this is kind of the real kind of main compliance administrative rule I would recommend that you familiarize yourself with. And it's going to be our through line. You're going to hear me say the word SOP probably a million times in this presentation, but they're very important, and we're going to tell you why. So go ahead and kick to the next slide, please. So what do we mean by SOP? It is literally the procedures that you educate and instruct your staff, employees, owners, and managers on to make sure that you operate your facility in compliance with all the rules and obligations of the license type you're operating under. Like I said before, CRA can request them, and one of the most important things about them is if you are in an enforcement situation, if there is some sort of investigation at your facility, it is one of the main items we use when we are in negotiations with the CRA for penalty, fine, and enforcement resolution. The more proactive you can be with these, the more likely you are to mitigate whatever enforcement, fine, or penalty you suffer should your facility make a misstep, or should you do, in fact, get caught violating something as you operate. Go ahead to the next one.
So at the firm, I am often tasked with writing and supporting teams with how they should create their SOPs. This slide includes a general overview, but the guidance that I cannot stress enough is that the team implementing the procedure should take an active role in writing and implementing the standard operating procedure. Where I see this work the best is if that team takes the first draft and another person with an eye on compliance and the regulations comes in to edit and also confirm that they understand the work instruction for the procedure itself. This comparison process, as well as having a complete novice look over the details in the standard operating procedure, will ensure that your training and protocols that go into place around that standard operating procedure are very clear and able to be followed.
And just to, let me jump in here. So just so everyone's on the same page, anyone that is currently a operating cannabis facility in Michigan has by default some application required standard operating procedures. So even if you've never written any additional customized SOPs for your facility, every license holder in Michigan has a business location plan, a security plan, a technology plan, a marketing plan, a staffing plan, and an inventory and record keeping plan. Those documents get reviewed by the CRA during your initial licensing period. And then they are, the expectation being that you keep them up to date and updated as you go on and renew those licenses. In addition to those, we strongly encourage that you write additional SOPs for the actual operations that you engage in at your facility. Genevieve, go ahead. I didn't mean to cut you off again.
No worries at all. That was exactly to my point. In Michigan, during your initial licensing period, when you're preparing documentation for review, you are often not already operating in the state. And once you have a couple weeks, a few production batches, a few sales transactions under your belt, you're already augmenting your standard operating procedures just with the cadence of workflow and how you're ramping up. So that's the period where it's important to recognize that what you submitted at the time of licensure is continually evolving as your time operating does. So that's where it's really important to make sure that you're auditing yourself, holding yourself accountable, and making sure that those documents remain living documents, and that employees are touching base with documentation that doesn't just give them a high-level overview of what you submitted at the time of licensure, but a real game plan for how to effectuate compliance in day-to-day operations.
Yeah, I can't tell you how many times we have been playing catch up. One of the client groups we're working with makes a packaging mistake or something. CRI is investigating it, asks us to provide SOPs, and lo and behold, no one has anything written on the topic, and we're helping that client group scramble to put, new SOPs together. It doesn't create the best enforcement mitigation situation with the regulators, and it certainly is a sign that that facility should probably be doing so that their employees and staff aren't just keeping everything up here. As we move forward here, we're going to kind of talk about some on-site kind of examples, but what you are required kind of as an overview is like a skeleton. Your business location plan, your security plan are talking about what is required of you by law in terms of cameras, locks, alarms, restricted access, and we'll put the legal language, and all of you have the exact legal language of how to destroy a product, for example. But when you actually apply that procedure to your unique facility, to your unique list, you need to think about, one, what am I required to do by law? And two, how do I teach my employees and ensure that my employees are actually doing the thing that I said we'd be doing? So for example, you all know that there are specific rules and requirements for destroying product. You need to destroy product on camera. You need to mix it with 50% inert material. But when you actually think about how am I going to destroy product at my facility, it's a little bit more complicated than that. You have to destroy the product on camera. Did you actually create a space to destroy product that has a clear view on that camera? Are there any obstructions? Have you explained to your employees that they shouldn't be blocking the view of the camera with their body as they're actually engaging in the activity? Are you showing the camera information and data that you can then point to 20 days later to show to the CRA if they're looking into it that, yes, I did destroy the actual product that I said I did in Metrc? And you could get as nuanced and detailed as you have the time, resources, and dedication to do. There's no minimum standard in Michigan to say anything more than is required for you in the initial licensing period. But if you actually want these documents to help, the more effort you can put into them and the more you actually train your team on them, the more likely it is you're going to avoid enforcement procedures in the first place. So go ahead, Jen.
Yeah, I want to dive in on one point there a little bit further, just to make sure it's really understood, because I think you provided such a good example when you're talking about security cameras. At the onset of your operations and through your initial licensing period, your requirements are to install and maintain surveillance equipment with very detailed specifications. And if you list all of those in your SOP, by the time your employee looks at it, that's already installed as far as they're aware. They are not, involved in the selection of that equipment. Give your employee day to day the checklist for making sure that all of the cameras are on. Are there any block spots? That's where that pivot exists from, that high level regulatory requirement to then let's make sure we are continually 24/7 complying with that requirement by doing these things.
Yeah, and I'm sure all of you have looked at in a employee handbook, 80 pages of legal jargon and read every word with significant detail. I tell a lot of my client groups that are working on issues like this with me, what you really are trying to do in a SOP that's actually being used is you're creating a kind of a script, an outline, how to do this for dummies, kind of simplified overview, so that you make it very simple. The goal should really be, I'm a new employee. I have no idea how any of this works. It's my first day, and I need to learn how to, for example, destroy product. I should be able to look at this SOP, and it should be very simple and clear. These are what I have to do. These are the important steps. This is how I document that I did it correctly, so that if something were to happen to me, and God forbid something terrible happens, we could go back, make sure that we have documentation that it was done correctly and documentation that that person was trained on it so that we can trust the outcome that we have in our system is in fact what did occur. The more that you have time to do that, obviously there are certain aspects of operation. They're a lot more significantly time consuming and significantly of more importance than some of the little things, but it's the little things that'll kill you. If there's something that you think is so easy, no one would possibly ever think to forget to lock the door when they left, well, then I guarantee you that's what the enforcement action is going to be, because people aren't kind of thinking about how to operate a highly regulated facility in this industry. So what we say culture of compliance, it's really just making sure you've created a system to mitigate the risk of violating these rules. So let's go ahead and jump to the next slide. Awesome. So, and I'll let Genevieve kind of jump back into this one as well, but obviously we start with initial SOPs, we start applying those SOPs to our facility, and then almost guaranteed, you'll learn that certain things work a little different in practice. You want to talk to us about that?
Yeah, so I think a part of this is really going to be kind of the documentation of any steps that are taken to address areas of non-compliance, and making sure that those materials are organized. I'd actually like to hop to the next slide for this one, just to give a visual representation. Oops, perhaps it wasn't this slide. We can just stay where we are. Generally, a corrective and preventive action plan for your SOPs. It's something that's often followed in a quality management system or quality assurance program. I really want to emphasize that these corrective plans are not intended to be punitive. This is a solution designated to create an actionable change in your operations, understand the root cause of why or how things have gone wrong, and serve as a training opportunity to address these SOP edits. And we will have another slide that'll kind of address how quality assurance programs commonly implement CAPA programs, and I'll dive in further there. But this slide does provide kind of an overview on how to review and update the SOPs. A lot of this is in line with what Travis and I have been saying, and communicating updates to your team, recognizing when the SOPs don't actively reflect what's going on day to day, and checking to see if there are areas that are missed or areas that could be better bolstered.
Yeah, and pay particular attention to number 3. When you have a proactive approach to implementing SOPs in your facility, you can use the resources available to you. The Cannabis Regulatory Agency also wants you to operate a compliant facility. Obviously, there's going to be situations when you need to be strategic about data that you disclose to the folks that regulate you. But if you're unclear as to how something should be done, don't be afraid to reach out to CRA. Don't be afraid to reach out to Metrc for clarification. It's better to get a question answered as opposed to trying to defend yourself because you made the wrong decision and now you're trying to kind of show them that you've learned how to correct it in reaction to an incident. So that I've worked with the CRA for since before that, it's what we called it. Most of the folks that work there, in fact, almost all of them are really, they're just trying to do their jobs. They're very nice people. They're very friendly. They're willing to work with you. It's when you become into an adversarial position, when you're being defensive, when you're clearly hiding information from them, that they're going to treat you in kind. They're going to assume you're doing something wrong and they're going to start investigating you accordingly. If you're dealing with ensuring that your day-to-day operations are in line with the law, then they're going to be incentivized to make sure that your understanding of that law is mirroring their understanding of that law.
Now let me hop in, because this was the slide I was looking for to address how quality assurance programs commonly implement CAPA. Again, just reiterating that this is not intended to be punitive. It's not a write-up of your employees. It's a time to collaborate, get to the root cause, and figure out how these small infractions that you're catching can be corrected and prevented from happening again. Outside of what quality assurance programs commonly address for CAPA, I encourage teams to implement this For small day-to-day details that you're catching, perhaps mislabeling or a missed SOP step, documenting that is a chance to learn more about your processes and procedures. And just because you document it internally and move through the process of reviewing those details, there is no requirement for you to self-report that activity. It's all information and education for your team. And it does often prompt where you'd be best suited to retrain your staff. Now we'll dive into using your SOPs. It's a very common occurrence for me that during third-party on-site inspections, I am getting a better understanding of how processes work, and I ask to see an SOP, and an employee will tell me that they don't have them. A manager, more often than not, does chime in and has this document in a Google Drive or other shared electronic file that folks directly involved on the retail sales floor or in the cultivation facility aren't regularly accessing. If your SOPs aren't accessible by your team, there is no way to be sure that they're meeting your standards and expectations. Don't go through the trouble of drafting and creating detailed SOPs only to forget to implement them into your training procedures. It's important to have them actively reviewed by compliance staff and set expectations for using this documentation and put all of that good collaborative effort to use. It's also not uncommon to see SOPs take different form in different departments. And I want to stress that because it's okay. I encourage teams to create a universal template with guidelines that they want in the SOP, but to understand that processes written down for the needs of your team will vary. An example of this that Travis and I have talked about previously is that your accounting team's needs may be pertaining to tax collection, for instance, may be very different than your manufacturing team's needs for calculating potency. You can be firm with your intention for the SOP documents, but slightly flexible with your form. Those variations in the documentation is how you know that the documentation is actually going to be implemented and used. If there are sections that don't quite apply to the accounting team, they can augment it however best works for them.
Right, and we've been kind of using the regulatory agency as kind of an example of how SOPs help you. We started off with enforcement actions and things, but it's also important to remember that if you actually implement your SOPs, you train your staff on these SOPs, there are other benefits as well. I'm certain that any operating facility has had great employees, but they've also had some bad ones as well. If you have a pattern and practice of, educating staff on SOPs and making sure auditing and doing reviews internally to ensure folks are actually following them, and you start building a pattern of behavior where one of your staff is, clearly not looking at the SOP, not following the SOP, instead of having an enforcement action problem with the CRA, you can do an internal, staff correction if someone is putting your license at risk. When I say these are highly regulated industries, it's I'm sure, unfortunately, all of you probably know, these are very expensive, very difficult, and very competitive license types to get. You don't want to jeopardize them because you didn't supervise staff and aren't checking to make sure they're reading all of the SOPs you've put time, resources, and effort into creating. That culture of compliance is really more of an internal approach so that you are ready to deal with external issues. So, we just another few examples of different places, like as Genevieve said, you don't need to train every staff member on every SOP. There's obviously going to be some, some judgment calls here. Your managers are going to know who's responsible for what. You want to set clear expectations. You obviously don't want to overwhelm folks who don't need to know, accounting principles when they're, day laboring and working with their hands and things. But it is important that, there are certain types of requirements that are across the board and certain types of requirements that are very applied to the task at hand. And part of your approach when you're kind of creating an SOP strategy and documenting it is as Genevieve said, not only making sure everyone knows where they are, is actually using them and reading them, but makes it easy for them to know. If you have an issue that's a human resources issue, maybe you don't deal with that very often, but you should know, like, well, now it's time to go see what our internal policies are on that issue. The more that you can demonstrate that you have taken proactive approaches, the better you're going to be at actually dealing with that problem yourself before it becomes a time-consuming and expensive issue to mitigate.
I also wanted to emphasize that, earlier we talked a bit about how the SOPs that you're required to submit at your time of licensure look different than the SOPs that you're implementing for day-to-day procedures. And this rundown of the various departments that are leveraging use of those SOPs does exemplify that. There are different ways to kind of implement resources and materials for those teams that dive deeper than what you provided at the time of licensure. Great. Now I'll dive in a little bit on the value of training and retraining your employees. When you write and implement an SOP on site, a key portion of that implementation is making sure that your employees review and understand the standard operating procedure, and that if they have questions or concerns relating to the processes, or if something doesn't quite make sense, they have the opportunity to ask questions. I do think it's also important that anytime that there is an edit to those SOPs, you are facilitating a retraining. Processes that change on site need to be appropriately addressed with staff so that they have the most up-to-date information.
Awesome. Well, we do have a few questions. I think we can definitely jump in and start trying to answer some of these. If there are any questions that you guys typed out that we either don't get to or that we skip over, I'll make sure that we shoot you an email afterwards and do our best to connect with you. It'll either just be kind of a little too complicated to explain on the webinar, or perhaps something that requires a little bit more kind of one-on-one discussion for. I'm going to try to use the feature here, but if I mess up, I might just read them out loud. Let's see, let me pick one out here. Here's one. Okay, so the question is, how much notice does CRA usually give about upcoming inspections? The answer is it depends on the type of inspection. There are some scheduled inspections. There are some inspections that are just objectively timed so that that they're going to occur. There's also inspections that will occur at some point that you'll receive notice for, and there's going to be unscheduled inspections. So to start, there's always a 30-day post-initial licensure inspection. There's often a 7-day follow-up inspection as well. Some of that depends on the license type at issue. And then the CRA is going to come in at least once or twice a year to do a scheduled inspection, which they'll typically set up with you via phone or email. However, any law enforcement officer or CRA employee can have access to your facility for an unscheduled inspection 24/7, all year long. So depending on what is instigating that, or it could just be, random auditing, they might roll up on your inspection, without any notice at all. However, in my experience, what typically happens is an inspector will reach out to you by email, find a time that works for you to come, kind of give you an overview of what they're going to be doing when they get there, and then meet with you and have you meet them and walk them through their facility. That's the standard issue there. Another one that's kind of in the same vein there. Let me pull another one out here. So this question, how long do CRA inspections usually last? That is very dependent on the license type. If you're a marijuana retailer or provisioning center where your facility is primarily just a retail storefront with security, those inspections, can be pretty short because there's not really much to see. You go through the limited access areas, restricted access areas, they check your vault, they check your books, they check kind of your staff areas to make sure there's not product and foods isolated out. They look at your camera systems and things. You know, if you're a large manufacturing facility, either a processor or combined cultivation facility, some inspections could take 4 to 5 hours as they walk through various rooms and look through various things, check your records. You know, if they're doing an audit of your Metrc records, you know, they could spend a significant amount of time. So, you know, in general, for a routine field inspection, it's been my experience, it's usually about an hour and a half, you know, kind of as a rule of thumb, but it really can depend. I don't know if there's some other questions we can pull out here that are easy to answer for this, and feel free to keep typing in more if you have them. I'll try to get to as many as we can here. Let's see. Can you speak to which violations are reportable or disclosable for owners? So there are a couple different types of violations or you know, what I call, you know, triggering issues that you have obligation to apply for. So there's a couple that are called out in the administrative rules and statutes. The first are for 3 situations. These are probably the most obvious ones. If there's any criminal conduct or criminal behavior or investigation in criminal issues at the facility, at the licensed facility's address on the parcel, if there's any sort of loss or diversion of product, or if there's any sort of theft that has occurred, whether it's, you know, suspected internal diversion or third party kind of breaking, entering, whatever it happens to be, consumers grabbing something, any of those issues need to be reported to the CRA within 24 hours. That is black and white. That is the rule. There are violations and fines should the CRA learn that it took you longer to notify them of that. There are a few other call outs in the administrative rules. If there's adverse reaction that you become aware of to your products, if there's other sort of like site issues, like a fire on site or things, you know, you also have an obligation to notify the CRA of those things. In general, the best takeaway you can have for this is if there's any sort of reportable violation, it is in your best interest to notify the CRA within 24 hours of you becoming aware of that. It demonstrates to the CRA that you are willing to basically play ball with the rules and obligations and work with them to resolve the issue. They're just trying to do their job, even if it's annoying for you to have to drop whatever you happen to be doing and tell them as soon as you can. I guarantee you a little pain up front will save you a lot of pain down the long run as you're kind of dealing with that. Let me just read through some of these here. Genevieve, Krissy, if you see any of these you want to pop out, by all means, I don't have to keep grabbing all of them. Let's see what else we got here. All right, here's a good one. So here's a question, and I hope everyone can see these when I click that, but can I give an opinion on how strict CRA is going to be with trade samples and products given to employees? So what we're talking about here is there are basically internal product samples and trade samples. These are ways that you can either, as a licensed facility, provide some of your product to other licensees, other company trade samples, or you can do our research and development through an internal product sample where there's a limited amount of product that you can give every 30 days to your actual staff to take home, test, make sure that your Q&R quality issues are where you want them to be. You need to treat those standards, those samples, just as strictly as you would treat any other Metrc sale in your records. You need to make sure that you have the appropriate Metrc data entered. You need to make sure that you have all of the you know, data and information collected, and you should definitely have a written SOP on how you're doing that and staying compliant. If there is an issue and CRA is investigating that issue, they're going to be just as strict about an internal product sample as they're going to be if there was some issue with a traditional sale to a customer. So I would highly recommend you treat that as strictly as you would treat any of your other issues. Let's see here, we definitely have some time. Let me grab a few more. All right, so with regards to Metrc inventory issues, are they looking for all inventory to be 100% correct? Or are they looking for larger issues? I mean, the rule of thumb is they're looking for any issue they can find. You know, you need to really take the approach that if a CRA regulator is in your facility, any violation they see is potentially going to result in penalty or fine. I would say though, in practice, you know, they're reasonable. They understand the realistic issues needed to do, you know, day-to-day operation. So, you know, there's a big difference between a slap on the wrist, you should have known better, and you're blatantly breaking the law. And there's a lot of gray area in between that very large path. So, in general, especially if you're in charge of compliance and it's your kind of responsibility for your organization to run a compliant facility, you should treat every issue with the seriousness that it requires. So, I would encourage you to start with that approach, and then, be reasonable about what you're actually dealing with.
Just to echo some best practices there. The standard is, yes, your inventory should be 100% correct. Understanding that operationally it is not feasible in many cases to do a full count of inventory every day. Create actionable bite-sized pieces for your team to be moving through on a very specific cadence and document that so that it is easier for you to identify any possible inventory issue on the spot. What I will say, and this is the case for many compliance issues, when they are not appropriately audited or verified and inventory issues go unnoticed, it is significantly harder to backtrack and clean up your Metrc or any of your third-party inventory management solutions months after the fact than it is to make any cleanup within the week. So again, while you're supposed to be shooting for 100% inventory compliance, keep an eye on what is operationally feasible and how quickly you can move through that cleanup process to make sure you are as close as possible to 100% at all times.
Yeah. And I actually found a question that I'm really glad somebody asked. So let me go ahead and click this one. The question is, does having SOPs on a Google Drive count, or do they need to be printed out? Rule 422.06a specifically says written. So if I were answering this question for a client, I would highly encourage that you have a printed copy, at least one, on the facility. Now, I do think that if those are living documents and someone on your team, I know that I work with some larger, very sophisticated client groups with multiple locations and things, that sometimes SOPs are changing constantly, and it's not feasible to necessarily print out each new version every day. Obviously, there's some reasonableness kind of in there. But have version control. I know we kind of ran through a lot of our slides to get to some of this stuff, but if you have a version 1, version 2, version 10, version 15 of your SOPs, it's in your best interest to save copies of all your previous ones so that you can reference them. Especially, this becomes quite relevant if there's some sort of CRA enforcement issue where maybe 6 months ago, the factual issue is being investigated, but since then and now, you've gone through 3 version updates of your SOP, you might need to show the CRA, well, what was in place at the time the incident occurred and how did you correct that by the time we got around to penalizing you for it. So, obviously in those cases, you don't need to have a whole library of printed materials at your facility, but you should have the minimum SOPs, and the ones I would require you to have printed out at all times are going to be the ones from your initial licensure, your business location plan and your business plan. I ran through those before, but they're the ones that you'd see right on the CRA's website in your checklist. And any SOPs that employees and staff are using day to day should be ready, accessible for them so that they can reference it. You want to really just kind of make a judgment call there on how important is this SOP to the amount of need my employees and staff are going to need, to implement the task. And in general, rule of thumb, the rule says written, so print them out, and then you'll be safer than if you don't.
And 2 different thoughts there. Travis touched on version control and making sure that you are tracking these updates. Include that documentation record within the SOP itself. I usually like to include it right there at the bottom so that it says the version, the update that was made, why you made the change, who requested it, who approved it, good to go, and the date you rolled it out. The other thing is, as Travis mentioned, making sure that those ones from initial licensure are very readily available, and anything that folks need to be checking while they're right on the manufacturing line or operating a point of sale system are easily accessible to them. But also keep in mind that however you implement your document management system is entirely up to you. I personally really love to use spreadsheets with hyperlinks to different areas where those SOPs are saved. And having the spreadsheet itself to serve as your larger index of additional SOPs that can be easily pulled does make your inspections go a lot smoother. I am a big fan of binders and spreadsheets when it comes to displaying any of your information for any regulatory agency, because it's a very clear and organized way to present the information and pull out what you need quickly. The key is making sure that you stay on top of updating those systems.
Awesome. Let me pull this one out here. I'm not going to read the whole thing, but it's basically, is there already a standard in place that you'd recommend a facility follow? Please respond, Jason, if I'm not quite understanding your question the way you intended it. But we had a slide early on. I'm not sure we can go back to it, outlining the statutes, the rules, the bulletins, and other things. What we would highly recommend when you're initially writing your SOPs is that you start with the statute and the rule. You pull out all of the ones that apply specifically to your license type, the way you're going to operate your facility, and that is the backbone that you add the kind of skin and bones and muscles to as you kind of flesh out the SOP for your facility. At the end of the day, you might want to recommend that your facility operate in a certain way, but you have an obligation to follow the statute. You have an obligation to follow the administrative rules. You have an obligation to follow your municipal ordinances, and certainly any other guidance the CRA puts out unique to your license type. So that would be the standard you start from, and then it's really just best practices from there to ensure that you make them actually work for your facility.
And just to chime in here, it looks like the references that are dropped are the federal regulations for good manufacturing practices. And yes, I do think that is a gold standard when you're moving through your cannabis operation SOPs, though we are not seeing a ton of enforcement against those federal regulations right now. It's something we need to keep an eye on.
Yeah. And, I like to tell people too that, there's a lot of good resources out there, both direct resources from the regulators and the law. And also, as I'm sure you're aware, groups like ours and other companies out there that are kind of offering compliance assistance. Just remember, at the end of the day, you have an obligation per your license to comply with what the CRA and the law tells you to do. So if you get great advice from maybe an example or something, or maybe from a colleague that's working for or operating in another facility, how they resolve something and what their operating procedures are, certainly, don't reinvent the wheel, but make sure that you verify that what you're being told is actually what the rule and statute says you need to do. Because at the end of the day, that is the standard. The CRA is not going to care if they're fining you because you violated some administrative rule, and you tell them, well, we got this from my buddy who also runs a grow facility, and that worked for their situation. Certainly can be sympathetic, but it is not going to resolve your enforcement issue. So, all right. Here's another one. Are there red flag compliance issues CRA looks for in safety compliance facilities? There are red flag compliance issues the CRA looks for unique to every license type. If you are specifically wondering, like, what is the enforcement priority for, the testing labs, safety compliance facilities, obviously testing is a very important part of regulatory concern in an industry like this. So they are going to be much more focused on some of the scientific, testing best practice issues. They have a special investigator that is trained in, testing issues. It's honestly a little bit scientifically above my head here, but in general, they are much more focused on, making sure that you're complying with all of the, safety quality control standards for accurate testing, for product management, and for, contaminating and making sure, like, if there is a poor test, it's not also contaminating other tests that are still ready to go and things of that nature. They're also very strict with a lot of the things they're looking into specifically for safety compliance issues, because they want to make sure that, these facilities are held to the highest standard to make sure any products actually hitting the market are safe for consumption. So the best way I can really answer your question there, Paul, is, yeah, you're even under a larger microscope than normal. Not that every facility isn't, kind of really focused in on when CRA is doing investigations, but that's a license type where you really need to be on top of things, and probably not that it isn't important for all of them, where I would recommend having some very unique to the task at hand SOPs on how you're implementing your testing procedures and making sure that you're verifying everything.
That in mind, there was an inquiry regarding the background that the compliance person should have. Please feel free to send me an email after this. I'm happy to kind of talk to you one-on-one about the needs there, so that we can kind of unpack your specific circumstance.
And I think we're going to have time for one more. And like I said at the offset before we kind of sign off here, if there's any questions we didn't get to, or if there's any questions that kind of come in after the cutoff here, I am more than happy to, and so is everyone on the call here, to try to get answers to you. We'll respond to you by email if you provide that to us. And if anyone thinks of anything that they didn't think of until later, please definitely feel free to reach out to us. I'd love to answer questions and see if there's anything we can do to jump in and set you on the right path. So I'm just going to pick out one more one here. The winner is, let's see. All right. What are my views on CRA enforcement priority for social media, website audiences, composition of threshold age? What kind of data would be required? That's actually an interesting question. So what is really at issue here is when cannabis facilities are advertising in Michigan, they are required by law to ensure that the audience of those advertisements are of a certain age group based on either medical or adult use. It's, I believe, 17 and 21, but I'd have to look at the rule. I don't have them all memorized. But basically, you need evidence to support that your advertisement is hitting a market that has a significant population of that age group. Don't quote me on this. I think it's 30% or less. It's in the rules, so cite to that. So if you're doing online social media advertising, which is certainly possible, instead of asking what CRA is going to request from you, you should proactively know what you're going to show the CRA to show that your audience is of the particular percentages of age groups there. So I'm sure there's a lot of forms that evidence can take, but before you engage in that advertisement, you should know before you even start that the audience population is compliant, not just assume it is, and when CRA asks for it, come up with something. So I hate to flip that on its head for you there, but the real advice here would be, if you are developing an advertising SOP and you're going through the administrative rules and statutes on advertising restrictions, you should start with, we need to make sure, the advertising population is at this threshold. Do we have evidence to show that it is? If the answer is no, then you shouldn't let that advertisement hit yet. You should make sure that evidence is ready to deploy, and it's in your best interest to make sure you have it on hand so that as soon as they ask for it, you can be, here you go. That's kind of the attitude that I'd like you to try to take away here for almost all these issues. That's being proactive about your SOPs, and then, making sure that you're implementing them as you kind of go here. So sorry if that didn't exactly answer your question.
Well, and just to mention for the person that had that inquiry, please also reach out to me by email. We do have, it is not Michigan specific, but we have a general social media compliance guidance document that can give you a rundown of the best practices to take when you are engaging in any kind of social media activity with your cannabis business.
And Travis, you're right about those numbers. It's 17, 21, and then 30%. So
I used to know all the rules and stuff by heart, but they seem to change every
well, you're right,
months, so you have to bear with me. So yeah, when in doubt, read exactly what it says and go from there. Well, thank you so much for joining us today. This has been recorded, so if you only caught part of it or jumping in at the end here, thanks for joining us. Thanks for everyone who's with us from the beginning, and please reach out to us. Here's our emails. We'd be more than happy to have initial consultations with you on these issues. I'd be more than happy to schedule a sit down and talk or jump on a Teams call to go over and see if there's anything we can do to help. We have quite a robust compliance kind of offering and department here. Genevieve's great. I highly recommend anyone who has compliance concerns to reach out to us. She'd be happy to work with you. And we just want to see you succeed so you can go out there and make as much money as possible. So thanks so much for joining us. We will be having another one of these soon, so stay tuned for that. Thanks again, guys.
Thank you.